Hello everyone. So we will be beginning with unit 5 in this video, and as I have told you in one of my previous videos that this is the updated version of NCERT book. So according to that, this is unit 5, and the earlier chapters which were not covered because of the updation, till now I have not covered it. So what I am thinking is I will be covering it after the whole book is over. The new chapters will be covered thereon. Okay, so let's begin. Institutional framework, marriage and divorce. The basic meaning of these two terms I think everybody is aware of, right? And you need to keep one thing in mind, that marriage and divorce are governed by personal laws. That means according to the religion to which a person belongs. Okay, so it governs according to Hindu law if the person doing marriage or claiming divorce is a Hindu, and it will be governed by Muslim law if the person getting married or claiming divorce from his marriage is a Muslim. Similarly for other religions as well. Okay, and under Hindu law you will have Sikh, Jain, Buddhist. Also they may claim that they are separate religion, but under Hindu law these people are included and they are said to be a Hindu. Okay, so let's begin. Nature of family laws in India. What is marriage? What is divorce? Marriage is institution of a family, right? A family begins when a person marries, right? It is the bond between not only two persons but two families. We say these things, right? So what is the main purpose of getting married? To further the generations, or to create an emotional bond, or to get a support for lifetime, right? To get a person who will be by your thick and thins. Yes, so these are known as family laws. Okay, family laws or personal laws consist of family or personal matters like marriage, dowry, dissolution of marriage. Dissolution means to dissolve, khatam karna. Guardianship, adoption, all these are related to child. Maintenance, to wife, to elderly parents, or to the child who is unable to maintain himself or herself. Wills, inheritance, succession, all these are related to how the property of a person will devolve upon his legal heirs, right? In India, religion and personal laws are interlinked, as I told you. So Hindus, Sikhs, Jains, Buddhists follow Hindu family laws. Sikhs have their own marriage law but are covered under Hindu law for other family matters. Muslims, Christians, Parsis have their own laws, and other traditional communities like tribal groups follow their own customary practices. Now, custom also is a source of law if we have done it earlier. A custom which is practiced for a long period of time continuously and is taken over from generation to generation without, or some minor changes may be there. Such custom can have the authority, can develop the authority of a law, and it can be applicable as a law, right? So the customary practice or traditions, that can also have a place in how a marriage will be conducted, or the personal law of that particular person. Sikhs have their own marriage law, like Anand Karaj bolte hain. In Hindus we have Saat Fere, that is Saptapati Gamanam, but in Sikhs we have Anand Karaj, that is 4 feras in Gurudwara. So that may be a separate law, or it can only form a part of tradition in Sikhs. When you will study Hindu Marriage Act, you will get to know it. Other than that, in any act in which you see Hindu written, Sikhs, Buddhist, Jain are included in the category, in the definition of who is a Hindu. Okay, so remember that. Hindu law, Sikh marriage law, Parsi law, Christian law are codified or passed by the Indian Parliament as acts or laws. So you have to remember that the specific religions, Hindu, Sikhs, Parsi, Christian, all these laws are codified and Parliament has duly passed it. When it is Hindu Marriage Act, Hindu Succession Act act means something, some order, some law which is formulated by the legislature. So from that word act only it is clear. Muslim law is uncodified and based on Sharia, which is the moral and religious law primarily grounded on the principles of the Islamic religious text, the holy book Quran, and examples laid down in the Sunnah by the Islamic prophet Muhammad. So as far as I know regarding Muslim law, it is based on Sharia, and Sunnah means whatever they have heard, whatever Islamic Prophet Muhammad said and the people heard, and the way it was passed on from generations to generations. It is only on the basis of what they have heard कि वो ऐसा करते थे, वो ऐसे जीते थे, वो ऐसे खाना खाते थे, वो ऐसे रहते थे, all that whatever they have heard from hearsay, you can say, from generations to generations, that is Sunnah. Sunnah means related to hearing, okay, and Sharia is whatever his actual conducts may have been. Okay, so these are the two different sects in Muslim religion, you can say, and these are basically grounded or based on the principles of Quran book or by Islamic Prophet Muhammad. India follows a peculiar conception of a secular state. Although these varied communities are one nation, they coexist as independent, distinct communities in matters of family laws. Now we have a secular country, but we also have Article 25, Indian Constitution. So these all different communities, they may exist together in one nation, as one nation. Their nationality may be one, that is Indian. They exist, they coexist also, they live together. But these different communities become different in the matters of family law. Unlike other laws in force in India, like criminal or civil, family laws are not uniform. Okay, civil law is same, criminal law is same, IPC, CRPC, Constitution, TPA, SRA, Limitation Act, these are all uniform. But family laws are not uniform. Uniform here is of the sense that it applies equally on everybody. That's why the talk is going on of Uniform Civil Code under Article 44, which is DPSP, Directive Principles of State Policy. That is a goal or aspiration which was set by the then constitution framers of our Indian constitution, and they had speculated or predicted that there will be a time suitable when India has to respect all religions. It is secular, fine, but on the other hand, as the other laws apply same on everybody, regardless of he belongs to any race, caste, sex, religion, or whatever language he speaks, or whatever ground it is, but it is applicable equally, right? You may have seen there is nobody who says that I am a Hindu, so IPC is not applicable on me. Make a separate criminal law for me. Or a Christian or a Muslim saying that. No, they don't want a separate constitution or IPC, CRPC, etc. Right? So that is uniformly or equally applicable to everybody. But family laws में चीज़ें different हो जाती हैं. इसलिए उसी aspect को भी uniformity देने के लिए there is a debate going on whether UCC is a need of today or not, whether it should be passed in circumstances that India is facing currently, or it is not suitable, that this is the correct time to pass it. Okay, so you can also search for it and have your own views after gaining knowledge, not half-baked knowledge, but try to find out what UCC is, what are the pros and cons, and what are the arguments in favor and against it, and then you frame your own opinion. Okay, this provision, that is DPSP, is a directive or aspirational and not enforceable by a court of law. But obviously these DPSPs, from these DPSPs only various socio-economic policies are developed by the government, and according to these DPSPs, since these were mentioned in the constitution with the goal that in future there will be a suitable time when these, on basis of this, a law can be framed. So that's why UCC is in hot debate right now. Okay, so what will happen in UCC basically, like family laws will also be uniform. There is a major difference between adoption, the marriage of different religion. Like Hindu, there is monogamy allowed, that is single marriage, right? You cannot marry again if your spouse is living. But in Muslims there is limited polygamy allowed, that is a male can marry maximum 4 times, right? So ये जो डिफ्रेंसिएशन आ रहा है, अडॉप्शन में जो डिफ्रेंसिएशन आ रहा है, डाइवोर्स मैटर्स में जो डिफ्रेंसिएशन आ रहा है, मेंटेनेंस राइट का देयर इज शाहबानो केस, राइट? देयर इज मुस्लिम women protection act. So there is no provision of maintenance to wife till she remarries. In Islam, maintenance is only paid by the husband till iddat period, 3 months period after divorce or dissolution of marriage, that is iddat. Iddat spelling is IDDAT. Okay, it's a 3 months period, or you can say 3 menstruation cycles of women, of wife. Okay, so these are various discriminatory provisions, and to make it same and for the welfare of the vulnerable sections of society, of the affected persons who are affected by such discrimination, okay, UCC is in talk. There is a case, Shreya Singhal versus Union of India. In that also the matter is same. Person was married once, now he wants to marry again, spouse is living. What he does is he converts himself into Muslim religion just to marry. So Shreya Singhal में ये held हुआ that you cannot change just because your purpose is to marry. That cannot be allowed. You cannot take benefit of your own wrong just to take a benefit of some other religion. You are converting yourself, right? So there is this case. You can look into it if you want. Let me write the name. So if you want, you can search. Versus Union of India. UOI is Union of India in short. But you cannot use, or you should not use, these abbreviations in your exam. Okay. Next, ancient period. Laws in ancient India were based on religious texts such as Dharam Shastra and Dharam Sutras. They are Sanskrit written text on religious and legal duties. Here the word dharam does not mean religion, it means duty. Okay, they provided rules for life of an ideal householder and contained the Hindu knowledge about religion, law, ethics, and so on. So laws in ancient India, basically, if I talk about ancient period, then Islam was not originally found in India. It came with the advent of Mughals, right? So these Dharam Shastras, Dharam Suts, they can only be found related to the Hindu knowledge, Hindu religion. Okay, and what duties a person has to inculcate, what duty he has to develop in himself towards others, towards himself, right? Or towards his religion. To be a religious person, he has to be devoted to God, does not kill animals, or does not pluck flowers, because punishments are prescribed for killing animal, for hunting, etc. So there have been these instances, these content in these religious texts. And earlier we were only having Sanskrit language. That's why these also are written in Sanskrit. Okay, so remember, dharam here does not means religion, but it is duty. Medieval period. Hindu legal system in medieval period was based on smriti culture. Smriti means whatever you remember. So I have told you something, I have recited something in front of you, you have listened it, and when you go to the third person, how much you remember, that you are conveying to him. Like we did in the previous class something ki FIR tabhi register karwani chahiye when you are in fresh memory of the incident, right? Because it may happen that with the due course of time, as the time increases after the happening of incident, you may forget the correct point to point instance which has happened, or you miss some point, or you add something of your own, right? So smriti literature is what you remember. Smriti means remembrance. Dharam Shastra as well as other digests. Since medieval period, starting from 8th century, Two major schools of personal laws have followed: Mitakshara in North and South India and Dayabhag in Bengal religion. So there were two schools of Hindu law: Mitakshara in North and South India and Dayabhag in the Bengal region. Muslims follow Shariat, which is uncodified law based on Quran. Hindu law and Muslim Shariat covered all aspects of life and did not differentiate much between morals, customs and laws. Means, as we say, every religion is more or less same. They teach us more or less the same thing altogether, right? Even during the Mughal Empire, between 16th and 18th centuries, Hindus and Muslims were ruled largely by their own sets of local customs and personal laws. Means, from the beginning, the people were given freedom of religion, and whatever religion they were following, whatever traditions or customs are in that community, they are allowed to be governed by it, follow it, and whatever, if there is a dispute, then whatever decision is given, that is also according to the personal or religion only. British India. British came in early 17th century. In the initial years, they were not concerned with various regional and local laws practiced in the subcontinent. So, since today, current India is not what we had in the 17th century. In India, there was Bangladesh included, there was Pakistan included, right? So that's why that time India, we refer it to as the Indian subcontinent. Okay, in the initial years, since their main purpose was to trade, because they had come to Surat to the King Jahangir to get to be granted the permission for setting up a factory in Surat, right? But later on their motives changed and everybody knows the history. So at that time they were ruthless, and divide and rule was going on smoothly, so they were not bothered about various religions. In 1772, East India Company established themselves as civil administrators. Means, they will be ruling, they will be executing the matters of civil nature, civil administrator. Warren Hastings, the first Governor General of Bengal, introduced uniform criminal law with the idea of equality before the law for Hindus and Muslims. And not only Hindus and Muslims, for other religions, other communities, tribes as well. But Christianity came into India with the advent of Britishers only. Okay? Or Portuguese in Goa. So the first Governor General of Bengal introduced a uniform criminal law for equality. In matters of personal law, he established that laws of the Holy Quran would be applicable to Muslims and Shastras for Hindus. As British had no knowledge of personal laws because their religion was totally different, right? So they thought कि ठीक है अपना अपना तुम लोग फॉलो करो, शांति से रहो, बट क्रिमिनल हमारे हिसाब से चलेगा. तभी मैं बोली थी कि ये जो IPC CRPC है, they were considered the shackles of Britishers because they made it according to the conditions which were prevalent in their country. It was not suited to the conditions of India. That's why we made our own laws after independence, right? To suit according to our situation, our people. Yes. So they had no knowledge about our religion. They appointed Hindu Pandits and Muslim jurists as consultants. Means they will be consulting them in courts. And this led to administration and development of Anglo-Hindu and Anglo-Islamic personal laws. Anglo basically refers to Christian. Okay, so when there was a mix of like judges were Christian or lawyers were Christian, but they were the consultants. Means आपके रिलीजन में इस मैटर पे क्या होता है, आपका रिलीजन इस मैटर पे क्या बोलता है, बस इतना उनसे सुना जाता था. अदर देन दैट वट एवर आर्ग्यूमेंट्स वर देयर और वट एवर जजमेंट हैज़ टू बी गिवन, वो सब इंग्लिश था. इंग्लिश जजेस थे, वो अपने लॉज अप्लाई करते थे लार्जली. एंड दे नो ओनली अबाउट क्रिश्चियनिटी. इतना नॉलेज तो उनको किसी और रिलीजन के बारे में था नहीं. आफ्टर 1864, system of court Hindu Pandits and Muslim jurists was abolished due to dissimilar interpretations and suspicions of corruption, and court judges interpreted the personal laws themselves. Now 1864, that is post First War of Independence. First War of Independence was a major setback for Britishers. As if वो नींद से जागे थे उस वॉर के बाद कि these people whom we were ruling over, who we considered as bloody, they used to say bloody Indians or fool Indians, but they can also revolt against us at one point of time. They can also show their power to us. They can also make us leave, force us to leave this country, and they were not ready to do that, obviously. Otherwise they would have granted independence back in 1860s only. So after the first war of independence, they even came up with IPC, because to punish those revolters. Okay, so they abolished the system of quote Hindu Pandits and Muslim jurists, since there were some suspicions of corruption as well. Corruption पहले बहुत होता था, अभी भी होता है, शुरू से होता है. पैसे के लिए इंसान कुछ भी कर जाता है. पैसे के लिए people used to even betray the nation or betray their rulers, जिनका वो खाते थे, जिनके महल में रहते हैं, जिनका उनके सामने उनकी बन रहे हैं, बट ऑन द बैक साइड ऑफ इट उनके प्लान जानकर वो ब्रिटिशर्स को बता देते थे जाकर, जस्ट सो दैट द किंग और द क्वीन में बी डिफीटेड. दैट्स वाई फर्स्ट वॉर ऑफ इंडिपेंडेंस वॉज बेसिकली नॉट सक्सेसफुल, मेजरली सक्सेसफुल. अदरवाइज इंडिपेंडेंस हमारा 1947 तक बात आती ही नहीं, उसी समय हो जाता. Anyways, what is done is done. So they may also have thought that we have been much considerate towards these people, and they have revolted against us. So now no system of quote Hindu Pandits and Muslim jurists we require. It was abolished, and then the English judges only, they interpreted the personal laws themselves. Interpretation that I have told you what it is. During the British rule, both Anglo-Hindu and Anglo-Muslim personal laws continued to develop through reforms, law commissions, and case laws. Case laws is precedents, and reform means law. As you know, law is a dynamic concept. Law commissions, whenever there is a need that ये कुछ crucial matter है and we need suggestions on that, so commissions are formed, as it happens currently. Post independence, next video.